understand, the NCSA is a high school league. That being said, today, what we will be discussing today is sensitive content. So for all those, keep in mind we're discussing sensitive content and the NCSA is a high school league. That being said, Mrs. Saunders, Mr. Lee, and Mr. Smith, if you're ready. Allison, Josiah, and Laura. Yes. All right, great. Then let's, one second, I'm not ready. All right, then let's begin. You have probably heard of the proverb of the three wise monkeys. The three monkeys are Mirazu, who covers his eyes and sees no evil; Kakirazu, who covers his ears and hears no evil; and Irazu, who covers his mouth and speaks no evil. The interpretation of this parable most often used by the Western world is that the monkeys symbolize those who deal with impropriety and evil by turning a blind eye to it. Unfortunately, such a parable applies all too well to our system of higher education today, as our system turns a blind eye to the evil of sexual violence on university campuses. It is for this reason that Calvin and I stand resolved the United States should significantly reform its policies regarding higher education. To better understand what we will be discussing today, we will look at the history and current policy of Title IX, starting with Fact 1, the law. Fact 1, the law. The law we are discussing today is Title IX of the Education Amendments Act of 1972. Title IX states no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. This means that publicly funded universities have a duty to uproot sex discrimination of all kinds, which has been interpreted to include sexual harassment and, by extension, sexual violence. Of course, Title IX was a dead letter without an agency to enforce it, leading to Fact 2. Fact 2, the enforcement. Fact 2, the enforcement. The Department of Education's Office for Civil Rights, or the OCR, is tasked with enforcing Title IX and other civil rights policies. According to The Atlantic in 2017, the OCR's primary responsibility is to enforce laws that prohibit discrimination on the basis of sex. Its ultimate enforcement tools are to withhold federal funds or to refer a complaint to the Department of Justice for prosecution. This leads us to fact. The OCR is therefore responsible for making sure that cases of sexual violence are properly handled under Title IX, in theory at least. In practice, the OCR has given universities practically no guidance for how to respond to such allegations. And the hasty, improvised policies that universities have produced as a result give us Fact 3. Fact 3, the results. Fact 3, the results. When students bring allegations of sexual violence to the attention of campus personnel, universities' policies as to what will happen next vary from state to state and even from school to school. Many do not notify the police, preferring to investigate matters in-house using ad hoc Title IX tribunals. This police optional approach is used by 94% of universities. Carrie Smith explains the current policy of the Office for Civil Rights is that universities do not have to report sexual violence to the police or investigate the sexual violence in accordance with local law enforcement. Rather, the Office for Civil Rights has allowed universities to handle these sexual violence claims independently, allowing them to adopt their own procedures and investigation without any oversight from outside agencies. Indeed, the criminal justice system plays such a limited role that untrained college administrators typically have the final say in ill-conceived kangaroo courts. The cost to alleged victims, to defendants, and to justice itself is incalculable. And today we present you with 3 harms. Harm 1, no uniform procedures. Harm 1, no uniform procedures. The Department of Education has issued Dear Colleague letters, and the Office for Civil Rights has issued best practices and guidelines. Colleges have scrambled to create their own policies to try to comply with all of these. However, there is simply no uniform federal procedure on the books for universities to use when a potential case of sexual violence is presented to them. And this leads us to Harm 2, decriminalized assault. Harm 2, decriminalized assault. A number of issues stem from leaving the investigation and adjudication of sexual assault to individual institutions. One is that cases of potential sexual violence go unreported to the police and are thus not investigated by them. The unfortunate impact of this travesty of justice was summed up by Danielle Elizabeth DeBoer when she said, at its worst, federal policy has fostered a radical administrative intrusion into the sphere of the criminal justice system, and has led to a systemic decriminalization of rape. This leads us to harm 3, everyone suffers. Harm 3, everyone suffers. The fact that universities are allowed to take a police optional approach to cases of sexual violence, coupled with the complete absence of uniform procedures for universities to follow when investigating and adjudicating these cases, has resulted in a system that's unsafe and unfair to all involved. It is little surprise that this results in stunningly low confidence in the status quo. The fact of the matter is college tribunals lack the experience, knowledge, and resources of the criminal justice system. Due to these factors, many colleges have been found to have improperly handled cases of sexual assault in ways that seriously threaten the credibility of the investigation. According to Julie Fay and Gary Starr, federal district courts have found that a college's failure to conduct a thorough, impartial, and fair investigation and fact-finding process created a flawed system. Some of the procedural flaws included the denial of an appeal despite the new information provided that revealed that the accused was innocent and that the conduct attributed to him was fabricated. In yet another court case, a university employee said male students were guilty until proven innocent. To allow such a woefully inept and actively destructive system to fester in our higher education system is the height of irresponsibility. It is high time we take action to reform such a system, and Calvin and I propose we do so through the following plan. Mandate 1, abolish the police optional approach. Mandate 1, abolish the police optional approach. The Office for Civil Rights shall abolish the police optional approach and require a mandatory referral of sex crimes to law enforcement. This consists of requiring mandatory referral of all accusations of sex crimes reported to college officials to law enforcement as a condition of federal funding. Mandate 2, abolish the single adjudicator system. Mandate 2, abolish the single adjudicator system. The Office for Civil Rights shall abolish the single adjudicator system. A single person may not serve as detective and prosecutor and judge and jury. And this leads us to Mandate 3, require uniform procedures. Mandate 3, require uniform procedures. The Secretary of the Department of Education will direct the Office for Civil Rights to take 1 year to develop strict and appropriate uniform procedures for universities to use in order to properly address claims of sexual violence in conjunction with law enforcement. This must be in accordance with the Administrative Procedures Act. These procedures shall be developed with the input of, at a minimum, the American Trial Lawyers Association, RAIN, the nation's largest anti-sexual assault organization, and the Department of Justice. These procedures shall be developed over the course of 1 year, upon which Mandate 1 and 2 shall also go into effect. In our next constructive speech, Calvin will be showing you some of the advantages of this policy, as well as explaining why this reform is so necessary. Remember Mirazu, Kakirazu, and Irazu, who covered their eyes, ears, and mouth to avoid seeing, hearing, and speaking evil. Though these monkeys succeeded in turning a blind eye to the evil before them, they did nothing to remedy the evil, and thus it festered. In the same way our higher education system does its best to avoid the appearance of evil, it does very little to back up that goal with true action. I ask you to have true action today, and to look evil in the eye and help defeat it with the affirmative team's plan. Thank you so much, and I now stand open for any questions the negative team may have.
Hi Sarah, I trust that you're doing well besides allergies, of course. I know personally that they're awful. So anyways, can I get a copy of Route 1AC real fast?
Absolutely.
Pass that back to Lauren.
There you go.
Cool. Now when you're talking about this, this not necessarily a court, but is it officially a court or is it just a board of individuals at college campus?
So what happens is when a potential case of sexual violence is presented to them, and specifically with what you're talking about,
Okay.
many times
Sarah,
the way
Sarah,
that
it's a simple question. Is it a board or is it a board of directors or is it simply just is it a court system itself?
the fact is, Josiah, that's not a simple question, specifically because of what Title IX looks like right now. The answer is there's not a solid answer to that question
Who's on
because
the
it
board?
varies.
Who's on the board?
That varies from state to state and school to school. That's why we need the affirmative team's plan.
Now, what exactly was the purpose of having this sort of this thing in place?
Are you asking about the purpose of Title IX?
Not Title IX itself, the board that we have on college campuses.
The fact is, Josiah, when you talk about a board, it's a lot more complex system than what you're trying to talk
I understand.
about. So what
What do you want to call it? Do you want to
about?
call it a body, a court? What would you like to call it?
All right, so
Yeah.
Josiah, when you say a body and a court, that in and of itself is not truly understanding how colleges handle sexual violence.
Is the
So I'm not-
purpose is this purpose of body of people deciding how to deal with sexual allegation on campus? Is the purpose of that to seek criminal conviction?
No, that's
No. Okay.
no.
Now, what exactly is the purpose of it then?
That varies from state to state and school to school. The fact is, these boards don't follow uniform procedures, and so they can have their own goals and their own aims at mind.
Okay, so let's talk about those uniform procedures. There are no uniform procedures, and you're basically saying that we're going to allow the government to create those uniform standards. Is that correct?
We're going to have the Department of Education mandate that the Office for Civil Rights, the organization in charge of Title IX, create procedures.
I understand
working
that.
with the
So we're
American-
allowing a federal entity to determine how exactly we're supposed to deal with essentially establish those standards. Is that correct?
We are mandating that the organization in charge of dealing with Title IX start dealing with Title IX.
Okay. Now you're talking about this particular policy of this body. How often are people expelled as a result of having this?
So first off, I'm not quite sure what you mean when you say body. However, looking specifically at your question, when we look at your question, the fact is we don't actually know because colleges don't release that. The reason for that is because colleges keep these cases in-house so it doesn't get released to the public that they have a problem with sexual assault. This is why it needs to be fixed. There needs to be uniform procedures and they need to be handed over to law enforcement.
How many colleges use the single adjudicator standard?
94% of universities use the police optional approach.
They use the police
Oh, I'm
optional
sorry, the
approach?
single
Yeah,
adjudicator
second one.
system.
Yep.
The fact is, we don't know because once again, this varies from state to state, from school to school, and with this specifically the single adjudicator process from case to case.
Okay, thank you so much.
You could start touching briefly, Allison. Thank you. How much is remaining?
4 minutes and 19 seconds.
Thank you.
All right, Mrs. Saunders, Mr. Wee, and Mr. Smith, if you're all ready. And Allison, if you're ready to time. All right. It's going to become very evident through both my and Josiah's speeches that there are a lot of things the affirmative and negative team disagree on. But before we go into all of these disagreements, Josiah and I want to make it abundantly clear that we completely agree with the affirmative team's goals and morals that they have set forth. In no way did Josiah and I ever want to condone sexual violence on campus, and in no way would we want to undermine justice. But what we're going to see throughout my speech and Josiah's speeches as well is the main disagreements we have with the affirmative team's policy are rooted in the effects voting affirmative will have. And so today in my speech, we're going to be looking through a couple of these effects. And the first argument that I have, I think is going to become one of the most important arguments in today's round. Ultimately, we need to remember when we're talking about issues of sexual violence, the victims themselves are some of the most important people in that process. It's important that ultimately they are the ones who are delivered this justice. But what the affirmative team's policy does is not actually protect victims, but makes the system worse. My first point for you is that it silences victims. The affirmative team's policy silences victims. We need to remember that there are very many reasons why an individual might choose not to bring their sexual assault case to the police and simply rather just to this higher education board with the understanding that they're not going to then go and mandatorily report it to the police, as the affirmative team's policy is. We're going to see this through a couple pieces of evidence. The first of which is by Jeremy Barr-Wolf, and he specifically said in 2017, quote, "Such a proposal, the affirmative team's policy, would create a chill among victims who are less likely to come forward if they know that law enforcement will be involved." Survivors say this often, said Daniel Carter, secretary of the advocacy group Serve Justice. But research seems to back the claim. Less than 5% of rapes or attempted rapes are ever reported to the police, according to a study by agencies in the research arm of the U.S. Department of Justice. Victims surveyed in this study stated that they did not want their family or other people to find out, or they simply lacked proof of their assault, unquote. It's clear that voting for the affirmative policy, if we actually look to what studies have concluded, is going to send a chill among victims where now they're not even going to bring it up to anyone in the first place. At least with the current system, if they choose not to go to the police, they still have a board that they can go to. Now, Sarah didn't really clarify in cross-examination what we can call this type of group, so I'm going to call this sexual assault board on campus. If that doesn't understand the issues in the affirmative team, could give us another word. But for the rest of the context, I'm going to be referring to it as that sexual assault board. And one thing we need to understand is the purpose of this sexual assault board. And as Sarah agreed to in cross-examination, it's not necessarily to determine criminality, as that's not the job of higher education. If we're going to determine whether or not someone committed a sexual assault crime, if a victim chooses, they can do so under the current system, they can go to the police. This is going to be another issue we'll talk about in my second point, but before we go there, I want to look further into how the affirmative team's policy truly is going to be silencing victims and making the system worse and not better. We're going to see this in another piece of evidence by Ashley Westerman in January 2nd of 2017. And she says, quote, "There are a lot of reasons victims of sexual assault choose not to report it. High on that list is fear of retaliation. So many victims won't come forward unless they can stay anonymous. The criminal justice system cannot guarantee that type of confidentiality for accusers and the accused. Further, when sexual assault is reported to law enforcement, a majority of cases will never even make it to trial. In fact, 3% to 8% of sexual assault cases actually lead to a conviction, according to research funded by the Justice Department." Unquote. Now, there are a couple of things that we can take from these two pieces of evidence we've read, but the main impact we need to understand is that when we're talking about sexual assault cases, victims are our top priority, and yet voting for the affirmative team is only going to silence them. Studies show that if we are going to be reporting these issues to the police, victims, it will send a chill among victims so they won't even tell anyone about the assault in the first place. That's why we need the confidentiality of these higher education sexual assault boards on campus and can't simply just report it to the police mandatory. But the second thing we need to note is that students can and have reported it to the police if they choose so. This leads me to my second point, which is that the criminal justice system is always an option. The criminal justice system is always an option. If a student feels like they weren't administered justice correctly, or they didn't get any justice for their crime, or for the crime that they believe was committed upon them through these higher education sexual assault boards, then they can go to the police. It's not like in the current system, these students are required to only go to these higher education boards. If they choose so, they can, and some do go to the police. The affirmative team is not creating a new option. They're forcing the victim's hand. They're essentially forcing the victim to actually report it to the police rather than letting it be the victim's choice. If that victim truly is a victim of sexual assault, shouldn't it be their choice to decide what they would like to do with that situation? And we believe the answer is yes. Ultimately, voting for the affirmative team simply silences victims and forces any victim's hand. Further, we see this reiterated by the Advocates for Youth, and they specifically said, quote, "Title IX requires schools to combat sex discrimination in education. One of the most common objections we hear to college campus adjudication is, but isn't rape a crime? And it absolutely is, and students who report to their schools can also report to the police. However, rape and other forms of gender-based violence manifest and perpetuate inequality, and federal anti-discrimination law recognizes that. To make sure that all students, regardless of their gender identity and expression, have equal access to education, schools are required to prevent and respond to reports of sexual violence. This isn't a replacement for reporting it to the police. It's a parallel option for survivors based in civil rights rather than criminal law." Unquote. What we need to recognize is in no way are victims not allowed to go to the police. The affirmative team, throughout all of their harms, their facts, and really anything Sarah said in the last speech, was that we need to have justice. And if a student feels like they weren't administered justice, if they truly want impartial justice, then the criminal justice system is always an option. Ultimately, voting affirmative simply forces the victim's hand rather than it being up to the person who feels assaulted in the first place. Once more, we see this reiterated by the Advocates for Youth in that same article. And they said, quote, first, federal law requires K-12 schools and employers who are subject to Title IX to respond to sexual violence. Yet Title IX doesn't take sexual violence away from the criminal justice system. It just gives students additional rights because equality is important in education. Still, the question points us to an important conclusion. Should we work to make sure all survivors have adequate civil protections, unquote. In no way are Josiah and I saying that the current situation or the current system is absolutely perfect. But what we need to recognize is voting for the affirmative team doesn't make the system any better. Mandating that colleges have to report any case of sexual violence to the criminal justice system is forcing the victim's hand. At the end of the day, if a victim truly wants justice, they can simply go to the federal court system. The affirmative team isn't creating a new option. The option is already available, and we believe it should remain so, an option. Because ultimately, it's not up for the affirmative team to decide for victims how they should deal with their own sexual assault cases. That is the idea of the victim themselves. So for these reasons, I urge you to vote negative. Ready for any questions, Sarah?
All right, Mrs. Saunders, Mr. Lee, and Mr. Smith, if you're ready. Allison. Hi, Lauren, I hope you're doing well today. Congratulations on breaking at regionals. I just have a couple questions about your speech.
Sure.
So first off, you talked a little bit about, well, you talked a lot about victims. You talked about victims. Allergies, okay. Do we force victims to go to the police through our plan?
Your plan is mandating that if a victim does decide to go to the I guess we're calling it a board now, to the sexual assault board on campus, and they're mandated to report it to the police.
All right, now do we say the victims are mandated to report it to the police, or are we saying the college administrator?
No, the college administrator is required to give that case to the criminal justice system.
All right.
Yeah, so you're essentially forcing
Now,
that victim.
secondly, can victims choose not to proceed with police investigation?
If a victim decides that they don't want it to go to the police and they want to remain that confidentiality, then they wouldn't bring it to the higher education board in general. Josiah, in his next speech, is going to further... Yeah, sorry.
Can you just answer my question?
I thought I did.
All right, great, all right. Should colleges be allowed to cover up possible cases of sexual assault?
No, and one of the things Josiah and I said is ultimately, we're not saying that the system is perfect, but your plan doesn't make it any better.
All right, thank you. Should due process be violated?
I don't think that due process should be violated in the criminal justice system, as that is its goal. But the goal of these adjudication boards, for specifically in higher education, the goal isn't to administer justice.
All right, great.
We agreed across that.
Specifically talking about those school boards, let's actually look at that. So to help the alleged, the goal of the school board is to help the alleged victim, correct?
Yeah, and Josiah's going to go in further how they do
Thank
that.
You. Yeah, thank you, Lauren. Now, to help the alleged victim, the college must first determine the guilt or innocence of the person they're investigating.
Not
correct?
necessarily, and that's something
All right.
Josiah's going to... Sorry.
You're fine. You're
Okay.
good. Should colleges be allowed to discourage students from going to the police?
Sorry, could you repeat that?
Should colleges be allowed to discourage students from going to the police?
Ultimately, it's that victim's choice whether or not they want to go to the police. I haven't seen any proof of examples of, or rather statistics on how a lot of colleges are specifically discouraging students.
All right,
to go
that
to the
being
police.
said, should colleges be allowed to discourage alleged victims from going to the police?
Sure, I don't believe that's something that we should generally encourage colleges to
All right,
do.
thank you.
It doesn't mean that we should pass their policy.
Thank you. Lauren, did you respond to our harm one?
Your harm one.
No uniform procedure.
No, I didn't. In my speech, Josiah's going to be addressing that.
All right, now did you specifically respond to our mandate two?
Your mandate to, no, and one of the things I talked about is we're not saying specifically that, again, this problem about the single adjudication system, that might very well be a problem within the system, but it doesn't matter, because voting for the affirmative team is still silencing victims.
Thank you, Lauren. Now, just as a final question, if we look at the affirmative team's policy, what is the negative team's main stance on why the affirmative team's policy cannot pass today?
In my speech, the two that I gave is because it silences victims, and because you're not creating a new option. The option already exists if students want to go to the police.
All right, great. Thank you, Lauren.
Sarah.
ready?
Yes.
As Eleanor Roosevelt once said, justice cannot be for one side alone, but must be for both. It is because of the current system of these ad hoc Title IX tribunals cannot administer justice in the way that is required by the Constitution and required by due process that I would urge you to vote for the affirmative team. Now, the negative team, in bringing up all of their points, has sort of missed the point of our case. Now, the point of our case is to bring due process protections into these Title IX tribunals. The fact is that currently they have no mandatory procedures and they are not required to report to local law enforcement. Now, in this speech, before I get into the specifics of it, I would like you to look back on what they said. They talked a lot about victims. Now, I would like you to know, every time you hear that term, that is not a legal term. Because in order to be a victim, it must be legally proved that you have actually been a victim of something. This whole idea of victimhood is essentially perpetuating the idea that you are guilty until proven innocent, that many of the adjudicators at these schools essentially hold. And so the fact is, these are alleged victims. However, it has not been proven that anything has been done against them yet. Let's start off with fact one, of it harms law enforcement. It harms law enforcement. The fact that we are letting these colleges essentially funnel these reports into an internal system and discouraging people from going to law enforcement is a travesty of justice. According to Hans von Spakovsky, who holds a Juris Doctorate in 2017. Quote, college rape accusers can, as the Hobart and William Smith cases demonstrate, actually suffer unnecessary harm by the current policies at universities. Instead of being encouraged to report the crime to competent professionals in the criminal justice system, they are unfortunately told that the criminal justice system is incompetent, uncaring, harsh, and cruel, and that the campus tribunal system is fairer to them. The opposite is true, unquote. These college boards are essentially discouraging people from reporting these crimes to the only body that could actually administer justice. This leads to fact two, a broken system. A broken system. According to Joseph Cohen, who is a Juris Doctorate in 2015, expecting amateur college panels to consistently make sound judgments about felonies without access to forensic evidence or the ability to subpoena witnesses or get testimony under oath is unreasonable, unquote. We cannot be leaving these issues to these Title IX boards. This leads, let's look at how far this problem goes with a piece of evidence from Robert Shibley, who was also a Juris Doctorate in 2016. It says, quote, colleges decide for themselves who will preside over campus hearings and who will serve as jurors. Such panels frequently include college administrators, whose employment prospects may depend in part on their reaching the conclusion most convenient for the college. Some colleges even appoint a single administrator to serve as both judge and juror. Shibley concludes by saying colleges frequently don't even record the hearing or explain why they came to their decision. I'd go so far as to say that not a single person at the Office for Civil Rights would believe it just if they or a loved one were to be tried for rape in a system using these rules, run by amateurs and in which one's guilt or innocence will be determined by a mere coin toss level of certainty. And the reason neither you nor they would agree to this is precisely because such a system is not, by any stretch of the imagination, just, fair, or equitable, unquote. In the entire negative team's last speech, they have misunderstood the depth of the problem. They have not fully grasped how much due process is not respected in these Title IX tribunals. They have essentially funneled, they have made themselves up to be a proxy for the criminal justice system, deciding people's guilt or innocence and then expelling them as a result. The first effect of this is that due process is demolished. According to Stuart Taylor Jr., who is also a Juris Doctorate in 2017, administrators have empowered campus bureaucrats to decide accused students' fates and trained them to view accused males as almost always guilty. Lawyers for the accused are barred from speaking in campus proceedings. The accused are often denied the right to see specific allegations or evidence against them. OCR-mandated procedures have largely demolished due process protections for many innocent, as well as guilty, accused males. Hundreds, if not thousands, have been falsely branded as rapists and expelled or suspended with life-changing consequences, unquote. Not only does this harm those accused, it also harms future victims of these crimes. According to Hans von Spakovsky, who is a Juris Doctorate in 2017, ironically, the OCR's guidance may well make matters worse for victims of rape. By tipping the scales in favor of an accuser, and coercing colleges to keep these cases on campus. Rather than referring them to law enforcement authorities, the OCR has put other potential victims in jeopardy by literally giving some rapists and other dangerous predators a get-out-of-jail-free card. The problem is that these issues must be dealt with as the crime that they are. We cannot leave it to a separate board that was instituted essentially to be a proxy for the criminal justice system, because it is not the criminal justice system. This leads me to my advantage of due process restored. Due process is restored. The only way to truly get justice is to leave these issues to the criminal justice system. According to Stephen Henrich, who has a Juris Doctorate in 2013, unfortunately, institutions of higher learning are hindered by several powerful and problematic incentives to falsely convict accused students in these types of cases. Removing claims of sexual violence from college campuses to civil and criminal judicial systems is the only viable way to fix the problem and ensure that sexual assault adjudication is equitable and impartial for all affected parties, unquote. Furthermore, the criminal justice system does have protections for victims of sexual assault. According to Hans von Spakovsky in 2017, perhaps the most persistent criticism of law enforcement handling of sexual assault cases comes from those who say that alleged victims should be able to remain anonymous, should not be confronted in a hearing, and should be able to change their mind about pursuing charges. These concerns are not foreign to the criminal justice system, which provides a variety of protections for victims, unquote. This is directly refuting what they said and saying that it does have protections for those who would wish to remain anonymous or fear that the criminal justice system might be harsh. Furthermore, let's look for support for mandatory reporting. According to Dr. Christina Mancini et al. In 2016, there was only one investigation that we could identify that directly asked the public about their perceptions of mandatory reporting, a 2015 poll conducted by Virginia Commonwealth University. The poll revealed overwhelming support, upward of 90% among the public, a sample of Virginians, for such laws, unquote. Furthermore, in this study, it showed that 56% of students would say that they would be more likely to report victimization if there were mandatory reporting laws in place. Only 15% said they would be less likely. The affirmative team has quoted a lot of activist organizations. Now, while we agree with the intent of these organizations, they have their blinders on when it comes to due process on college campuses today. And furthermore, they have made broad, sweeping assertions without providing any statistical data to back up their claims. We cannot leave this adjudication to boards that were never designed to deal with it. According to RAINN, the nation's largest anti-sexual violence organization in 2015, talking about this issue and how we need to leave it to the criminal justice system, said the fact that the criminal justice process is difficult and imperfect, while true, is not sufficient justification for bypassing it in favor of an internal system that will never be up to the challenge, unquote. I would urge you to vote for justice and vote for the affirmative. Thank you.
Alright, so Calvin, first of all, congratulations on qualifying to the octafinal round.
You as well.
Thank you. So I just have a couple questions for you, as I'm sure you'd expect. So my first question is, you essentially said that we shouldn't call them victims. So could you give us an alternative name that we should call them?
Alleged victims, essentially, if they haven't actually proven their allegations.
Okay, and then my next question is, you said how basically these boards on campus can give accused a get-out-of-jail-free card, is that
Yes.
correct? Okay, so if a student feels like the person that they are accusing got a get-out-of-jail-free card, you'd agree that they can go to the police if they so choose?
They might be able to go to the police. However, this is the primary system
They might
that
be
people...
able to, or they can decide to go to the police if they want to.
They can decide to go to the police, yes.
Okay, and then
That does not solve the problem that these colleges are handling these internally and telling people do not go to the police. It's
Okay.
harsh, cruel, and
Right,
incompetent.
so that's my question about that. Did you provide any statistics on how many colleges in general actually do encourage or do tell students not to go to the criminal justice
I did
system?
not, however, the logic implies that most colleges would use this system.
Okay,
Because there are, if I can finish, I can get back to you the reason.
Sure.
So the reason is because they have severe risk management proclivities, essentially. They want to keep this in-house because if they report it, essentially, if it goes to the criminal justice system, then it basically shows everyone this college has a problem with it.
Sure, and
no one wants it.
And I understand that logic, Calvin, but just to confirm, you haven't given actually any statistics on how many colleges do in fact practice this logic that you just explained.
I do not, however, the piece of evidence is very clear
Okay,
in
can I see
saying
that? Can I
that
see the
many,
piece of evidence?
yes,
Okay.
saying that this is the general idea of these colleges.
Okay, and then my next point, or my next question rather, is you talked a lot about due process and the insurance of justice.
Mhm.
So is it your contention that the purpose of these boards on campus is to administer justice?
The purpose of these Title IX tribunals, while it might not have been so in the beginning, is essentially to act as a proxy for the criminal
Okay,
justice
so it's
system.
your
That's how it
contention-
has become. That's how it has evolved. That is what it is today.
Okay, so it's your contention then that these college, or I guess you're calling them adjudication boards, or tribunals rather, specifically their purpose is, or rather now their purpose is to determine guilt and innocence of the victim. Or-
That is what they have done. Clearly, they cannot administer justice, as I provided throughout my speech. However, they have essentially tried to.
Okay, and then did you respond to the piece of evidence I said that the criminal justice system ultimately cannot keep victims anonymous?
You may have provided that piece of evidence, however, it was from an activist organization that has its blinders on when it comes to due process and not a legal expert, as I said it.
Okay, and could I see that evidence
Yes.
right there as well? Okay, and then one of my last questions for you is specifically in regards to my evidence talking about how it would silence victims. Did you give any direct response, either evidentiary or logic explaining ultimately how it wouldn't silence victims from bringing up the issue in general?
Yes, I did provide statistics showing that people would be more likely to report under mandatory reporting, and you provided no statistical evidence whatsoever.
Okay, and did I have that evidence, or could you give me that one?
I can give it to you.
Thank you, Calvin.
So this is just general support, and then this one talks about the.
Yes, please.